Before we begin the webinar, we would like to acknowledge the traditional owners of the lands from which we are broadcasting today. For me, I'm broadcasting from the land of the Widjabul people of the Bundjalung Nation. We pay our respects to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending the webinar today or watching the recording. So welcome to this Legal Aid New South Wales webinar on gender diverse and transgender people's experiences of the law. My name is Bridget Barker and I work in the Community Legal Education branch of Legal Aid New South Wales. This webinar will run for an hour and a half in total, and that will include time for questions and answers at the end. After the webinar, you will receive an evaluation survey and we really appreciate your feedback. You'll also receive an email with information about resources that we talk about in today's webinar. In today's webinar, we will be referring to both Commonwealth law and the law in New South Wales, and also services that are available in New South Wales. If you are joining us from another state, the laws in your state may differ from the New South Wales-based laws. I'll now introduce you to our panel in the order in which you will hear from them today. So a warm welcome to all of our panel. Firstly, to Joel Wilson, who has kindly agreed to share his lived experience with us. Welcome, Joel. We also have Shamika Pilagama, who is an accredited mediator and principal investigator conciliator from the Investigation and Conciliation Service at the Australian Human Rights Commission. Welcome, Shamika. We also have Hilary Kincaid, who is a consultant solicitor with Inner City Legal Centre. Good afternoon to you all. Joel, I'll invite you now to share with us some of your experiences.
Thanks, Bridget. My name is Joel. I use he, him pronouns. Now, I want to also first begin by acknowledging the lands on which I'm meeting from today, the land of the Kaurna people, the Adelaide Plains. I wish to pay my respects to their elders past, present and emerging, and extend that to any Aboriginal or Torres Strait Islander people with us here on the call today. This always was and always will be Aboriginal land. So what do I do? Well, by trade, I'm a software engineer. I spend my days doing that. But in my spare time and over quite a number of years now, I have been very involved in various aspects of queer advocacy. So 10 years ago, a little bit over 10 years ago, I first kind of started coming out. And for me, that was a multiple part journey, identifying as a gay transgender man, the realization that my gender didn't align with the sex I was assigned at birth, took quite some time. And there were a bit of, I could speak for a long time just in terms of how I got to where I am today. But today I want to talk more about some of the hurdles that I encountered along that journey, particularly once I came out as trans and began affirming my gender, and the barriers in particular that I faced with the services and systems that I encountered. So, as I said, it's almost a decade now, a decade ago that I came out and began affirming my gender. And at the time, I was actually in the Royal Australian Air Force, and I was enlisted as an electrical engineering officer, and I was studying at the Australian Defence Force Academy. And I became the first person to ever transition at ADFA. Now, as you can imagine, 10 years ago, the landscape for transgender diverse people was a little bit different than it was today. We fortunately have far more visibility and we've come a long way. We still have a very long way to go. There are still remarkably a lot of things that are unchanged. But I had a pretty rough time while I was at ADFA. There was discrimination, I was investigated for fraud, bullying, you name it, a whole lot of things were happening. And I was 19 years old at the time. Fortunately, I had plenty of support around me, and I ended up making the decision to leave. I really was left with no other option, but that was kind of where I went to try and preserve my well-being as best as I could. But transition regardless of whether something like that is happening for someone who is affirming their gender, it can be a really vulnerable point in a person's life. When you're coming out to the world and saying, I identify as a gender that doesn't align with the sex that I was assigned at birth, often the world meets you with an expectation to almost prove that you are that gender. And it puts you in this position where if the gender you identify with doesn't align with how the world sees you, the world just perceives us in very binary ways as men or women, and that's about it. So if you don't identify on that binary, or you don't look like a man or a woman, it can be quite a tumultuous point in your life. But the vulnerability doesn't necessarily end there. I'm very lucky. Very, very fortunate. When I go about the world looks at me and says, that person's a man. And lucky for me, I identify as a man. And so if I don't want to disclose my trans status, I don't have to, most of the time. But for a large portion of my community, that's not the case. Whether it be that they don't identify as a binary gender, or their presentation doesn't match what the world is expecting their gender should look like. It can mean that they're met with back when they're trying to access services, when they're trying to just go to the bathroom. It can be quite tricky navigating the world as a gender diverse person. But even if you're as fortunate as I am, in terms of having an easier walk through life, there's still plenty of points at which I'm kind of forced to disclose my trans status. How many people on this call have had to submit a police check for applying for a job? At that point, it asks you to disclose previous names, which for me means disclosing a female name. And depending on how that's handled, can mean that I am automatically outed to my prospective employer. Similarly, very fortunate. I'm just going through the process of purchasing a home, but applying for a first homeowners grant requires you just to disclose your previous names. And so I found myself just a month ago going, oh, I'm having to out myself to my broker, and I have no idea how they're going to respond. Now, as we kind of go along, I want to talk to some of my specific experiences to illustrate some of the good, bad, okay of trying to access those services, change names, all of those things. And whilst some of these experiences are quite a number of years ago, I'm actively involved in communities around Australia, and I'm still time and time again hearing these same sorts of stories coming up. People are still experiencing hurdles when accessing the services. And it's this combination. It can be an unfortunate combination of not knowing what you're entitled to, person on the other side, the person at the desk of said service not knowing what you're entitled to. But it can also be that you know what you're entitled to and you're having to argue the case to get access to that. So to really bring it to life, I many stories, but one of them, when I first began affirming my gender, one of the first things I did was I went and legally changed my name. For me, that was really important in terms of particularly progressing things at work, in the Air Force, but I then needed to go and change it at Medicare, my driver's license, you name it. Everywhere I'm having to front up and then out myself, I guess have that conversation with that service provider, that institution about I was trans and I was changing my name to Joel. So I fronted up to Medicare. Again, I'm an 18-year-old at this point. And I said, I need to change my name. And the person on the other side said, yep, great, can do it, was okay with that. And I said, and can I change my gender marker? At which point they said, they kind of froze. And this was a common experience, people freezing up and going, I don't know what to do. And this person said, look, I don't know, I don't think so. I'm going to go ask my supervisor. So went off and, chatted in a corner and came back and said, no, can't change your gender marker. You have to change the sex on your birth certificate. Now, I had no idea what I was entitled to at the time. And it turned out actually that person was wrong. all I needed was a letter from my GP saying that I'd had appropriate clinical treatment, and then I could actually change my gender marker in Medicare. And so because it wasn't information that was readily available, service providers didn't know, I didn't know, I just ended up having to have female in the system and still receiving letters to Miss Joel Wilson, all of the things that go along with that. And ironically, it caused me heartache when I lost my Medicare card 6 months later. And I called up to get a replacement, and the person couldn't find me for the life of them, not in the system. So, well, that's absurd because I've had a Medicare card my whole life. And they told me to front up to the Medicare office. So I went back to the exact same office 6 months later and sat down. And eventually the person at the desk found me, and they said, that's why they couldn't find you. For some bizarre reason, someone has put you in the system as female. Let me change it. So I watched that person move their mouse and click the male checkbox, and that was it. It was done. And I just went, oh, how strange. And was very lucky, again, because I was being perceived as a man, I kind of slipped through the system. But then I think, probably another 6 months later, I went to go get a male passport. Now, I knew some of the people in Canberra who were key to changing the legislation around passports and the sex on passports so that female, male, and X were available. And I fronted up and I had my forms. I could reference the documentation, and I got told, nope, not possible. And I said, well, actually, here's what I'm entitled to. And this person, no, can't happen. I said, well, can you please call someone from the passport office? And so we went through the process, and this is happening all inside of a post office, in front of a lot of people, and this particular person on the desk was not being particularly quiet, and I found myself in this argument trying to get what I knew that I was entitled to, until I was told eventually, you're going to have to book an appointment and actually go into the passport office. Fortunately, once I got there, they had someone who did actually know the system, weeks later, once I got to that appointment, and I was able to get a male passport. But I guess, I found myself in that situation, even though I knew what I was entitled to, and I was relatively articulate and able to, to kind of convey what I was entitled to, I still couldn't get access to it. And so, these are just two examples, but some examples, and sometimes we find that the systems are set up that we can't actually, they don't actually work, often because of data engineers like myself have set up databases that say if you've got a male gender marker, then you can only have Mr. And if you're a female, you can only have Mrs. or Miss. So I take that one as feedback for engineers. But I fronted up to my bank, and because of regulation, they can't actually change, for auditing purposes, they can't change gender markers unless your birth certificate is changed. But I got someone on the desk who said, look, I can't actually do this. So I can't put you as Mr., but what I can do is I can make you the Honourable. So for years, I was receiving letters from my bank saying the Honourable Joel Wilson. And it was just a lovely way of that person on the desk going, well, the system's not going to work, but how can we make it fit? What are the workarounds that we can do to make sure that you're not having to receive letters that say Miss Joel Wilson, and when someone is interacting with you, it's not going to throw up red flags, because unfortunately, when all of these systems are based on the assumption that someone is going to look like a man or a woman, and that on sight or on hearing of that person's voice, that you're going to know immediately the gender that they identify with, and that's going to be accurate. So I've had a myriad, and I could talk to many, many more experiences where I've come into battle with these systems and the people on the other side. And as I've gotten older, I've gotten much better at, standing up and saying, actually, no, I know what I'm entitled to, and can you please, let's escalate this until we can get an outcome that's suitable. But that's not always the case. And so that's where it becomes really, really pertinent that people that are peripheral to those services or providing the services themselves have an understanding, have the basic dialogue and literacy around trans and gender diverse people and what it means to be a part of our community, but also then know relative to their area, what are the things that trans and gender diverse community are entitled to? What are the workarounds? What are the things? What are the watch outs? And I really encountered this when I guess I was going through, when all this stuff was going down with defence, I was 19 by the time I left. And I was fortunate to have a number of people in my life who are human rights lawyers. And they said, hey, this isn't okay. This actually, you should really raise a human rights complaint and go through that process. And so it was only because, again, I had people who knew what I was entitled to, what actually wasn't okay and what wasn't acceptable treatment, that I was able to kind of get some advice and start going through the process of filing the complaint. Unfortunately, being one person against, it was a David and Goliath battle. David didn't win. I ended up letting that go because my mental health as a result of everything was just so poor at the time. But along my journey and through the Australian Human Rights Commission, I had people who understood my experience, who knew what I was entitled to, and were able to help guide me and inform me, help me make informed decisions about what to do next. And so I really encourage everyone who's on the webinar today. I really appreciate your interest and taking the time to listen, because the more you can equip yourself with the language to engage, and the more you're aware, you will be able to then step up and really bridge that gap. Because as individuals, I'm a software engineer. I'm not a lawyer. I don't know what I'm entitled in terms of the law. And so that's where I need service providers to actually be able to bridge that gap and inform me and help me make those decisions. So I hope this has just brought to life just a little bit of some of the barriers that my community can face when accessing just run-of-the-mill services, and hopefully will help you to really advocate on their behalf. Thank you.
Thank you so much, Joel. It's so powerful hearing from somebody with the lived experience, and it's just awful to hear the challenges that ordinary everyday things can cause gender diverse and transgender people. And thank you for being prepared to share your experiences with us all today. I'll ask Shamika to speak now, and I'll just move to your presentation, Shamika. Thank you.
Thank you so much. And thank you, Joel. That was really, really illuminating it. And thank you so much for sharing your experience. I just want to first acknowledge the traditional custodians of the land from where I'm speaking today, which is the Gadigal people of the Eora Nation. And I also acknowledge the traditional custodians of the land on which each of you are joining us today. And I would like to pay my respect to elders past, present and emerging. So as Bridget mentioned, my full name is Shamika Piligama. I'm an investigator, conciliator at the Australian Human Rights Commission. So I'm here with you for roughly, I think, 25 to 30 minutes. And I'm hoping to cover a few things specifically around protections under federal discrimination law for gender diverse individuals. Also, I'll be focusing specifically on the Sex Discrimination Act and what the law says in terms of what kind of complaints the Commission can receive. And I'll also be talking about our complaints process. So what happens when someone does make a complaint to the Australian Human Rights Commission? So firstly, in terms of who is the Australian Human Rights Commission? So we're an Australian national human rights institution, and we're an independent statutory organisation. So we are independent of government. We can take complaints against government. And we have a number of functions or mandates, which include investigation and conciliation of complaints that are made to the Commission. We also have a role in terms of protection or raising awareness and building education around human rights and people understanding their rights and responsibilities under the various pieces of legislation we administer. We also have a role in policy and legislative development, and we also undertake court interventions in relation to cases that raise significant human rights issues. In terms of where I'm from, so I'm from the Investigation and Conciliation Service. So the law, so the Australian Human Rights Commission Act, it essentially empowers the Commission to investigate and conciliate complaints alleging discrimination and breaches of human rights. So the staff at the ICS, as we refer to it, perform this function on behalf of the President of the Commission. We have around 30 staff, most of whom are based in Sydney, but we provide a national service, so we can receive complaints from all across Australia, all states and territories in Australia. I could move to the next one. Thank you. Now, in terms of the types of complaints that we can look at, I'm going to focus on that first group, which is unlawful discrimination, and I'll speak on that in a bit of detail, but just briefly, we can deal with 3 types of complaints: unlawful discrimination, complaints relating to equal opportunity at work, and breaches of human rights. The latter 2 we call complaints within an unenforceable jurisdiction. So essentially what that means is a complainant, whilst they can make a complaint, can't take a matter to the federal court to be able to get an enforceable outcome in terms of a judgment or any particular binding remedies. We can take those complaints in. If there's found to be a breach, the Commission can report to the Attorney General and make recommendations about remedies, but we cannot force the government or a particular respondent to agree to those remedies. So there's a specific type of complaints relating to equal opportunity at work, specifically around being able to make complaints on things like criminal record, trade union activity, political opinion, and religion. The most common types of complaints we get in under that category relate to criminal record discrimination. So where someone hasn't been provided employment or their job application hasn't been considered because of a criminal record. The third type of complaint is in relation to breaches of human rights by the Commonwealth. So it is only confined to the Commonwealth or agents of the Commonwealth. And this is in relation to where a person alleges that the Commonwealth has breached their human rights under specific human rights instruments, like the Convention on the Rights of Persons with Disabilities, Convention on Civil and Political Rights, or the Convention on the Rights of the Child. And the most common types of complaints we get under that category relate to people in immigration detention who raise concerns about the conditions of their detention and the length of their detention as well. In terms of those latter 2 categories, all our reports where we have made recommendations and findings are available on our website under publications for those who are interested. But today I'm here to talk to you specifically about unlawful discrimination complaints. If we can move to the next slide. These can be found in relation to 4 specific types of acts, which I've noted on the presentation there. So the Age Discrimination Act, Disability Discrimination Act, Racial Discrimination Act, and Sex Discrimination Act. The names in them of itself perhaps suggests what they cover. But essentially these acts all give people in Australia the right to make complaints alleging discrimination. Now, protections with respect to people who have gender diverse identities are covered specifically under the Sex Discrimination Act. But before I go to the SDA, as is known for short, I just wanted to cover just in general principles about what is unlawful discrimination that's common to all these 4 pieces of legislation. So essentially, in simple terms, unlawful discrimination is where someone's treated less favourably or is disadvantaged in some way because of a specific attribute in an area of public life. Now, when we talk about particular attribute, these are generally personal characteristics that are inherent to a person. And I will cover in a bit of detail what particular attributes are covered under federal law. But it's important to note that you can only make a complaint alleging unlawful discrimination where it relates to a specific area of public life, which I'll cover very shortly in the next slide. So the common areas of public life that are covered under all those 4 pieces of legislation include employment. So this can include casual, contract, part-time, full-time. So it is quite general. It doesn't cover volunteers, though, in a general sense, except for sexual harassment matters, which I'll get into in a little bit. So it's generally paid employment as it's commonly understood. It also covers education, so primary, public school. It can cover early childhood education services as well, so daycare services if there's an educational component there, as well as tertiary education, so TAFEs, your universities, your private colleges as well, so it's quite broad. Goods, services and facilities, so this covers a wide range of service providers, including state and Commonwealth government departments as well. And also we have protections in the area of accommodation, so who is accommodation provided to. In addition to those four, another common area is in the administration of Commonwealth government programs, so that sort of covers your federal service providers, which can also be captured under the goods and services provisions as well. In terms of grounds and attributes that are covered by those four pieces of legislation, this next slide sort of visualizes the areas or the attributes that are protected. Again, the labels themselves, some are obvious, some are not. So I won't go into every single one of them, but just a couple to sort of highlight. So under those four pieces of legislation that I previously mentioned, we can take complaints alleging race discrimination. Now, this is quite broad, so it covers things like race, skin color, national ethnic origin, and immigration status as well. And it also, under the race discrimination, provides for protections against racial hatred. So that doesn't have to be covered under a particular area of public life. It's where there's offensive conduct that's done because of race that's likely to insult, humiliate a person, a reasonable person. Under the Disability Discrimination Act, it's a really, really broad definition of disability. So it can cover past disabilities, current, present, future, and also imputed disabilities, covers things like temporary conditions or permanent conditions as well. So broadly encapsulate a whole range of disabilities there. And then the last one there is age discrimination. So that kind of covers too young, too old, or belonging to a particular age group. So we can take complaints in relation to those. The rest of those attributes, so sex, gender identity, intersex status, pregnancy, breastfeeding and family responsibilities, and sexual orientation are all encompassed under the Sex Discrimination Act. Just in terms of information, so 2013, there was a raft of changes to the Sex Discrimination Act that Joel previously had alluded to, that did provide positive protection for gender identity, for discrimination on the basis of gender identity, intersex status and sexual orientation. Prior to that, there was actually no federal protections on those particular grounds. So now there is in all areas of public life since 2013. I thought I'd just spend a little bit of time going through some of the definitions because I think that's quite important. Interestingly, under the SDA, sex is not defined under the Act. It's, I guess, commonly understood in the general terms that is understood in public, which sort of refers to a person's biological sex or sex characteristics, but it's been interpreted broadly in terms of a person. It can also include, obviously, less favorable treatment on the basis of a person's gender identity as well, so that the sex in which they identify as in the context of gender identity. And I'll go into that, so the intermix in a while. I'll speak specifically on gender identity and the definition in the next slide, but in terms of sort of intersex status, sorry, Bridget, I might just go back to the previous slide, apologies. In terms of intersex status, this refers to biological variations in sex characteristics. So being intersex means having physical, hormonal or genetic features that are neither fully female or fully male, a combination of female and male, and neither female or male. So it recognizes the diversity of bodies and identities. And then sexual orientation is defined or covers discrimination against people who are gay, lesbian, homosexual, bisexual, and heterosexual. Looking specifically at gender identity and the definition provided for in the Sex Discrimination Act in the next slide. So Section 4 of the SDA provides for the definition. So it means a gender-related identity, appearance or mannerisms or other gender-related characteristics of a person, which includes the way the person expresses or presents their gender and recognizes that a person's gender identity may be an identity other than male or female. You'll note that there's specific reference to gender identity, not by reference. So it doesn't really matter whether or not someone has a medical intervention or not, and without regard to a person's designated sex at birth. So some commonly used terms used to describe a person's gender identity include non-binary, transgender, and gender diverse. The SDA, so the Sex Discrimination Act, doesn't use those labels. However, it is intended to cover all of those identities and more. So it's the broadest possible definition under Section 4. So essentially the SDA then provides protection for discrimination for people who identify as men, women, neither male or female. And it doesn't matter, what the sex of the person is at their assigned birth or whether the person has undergone medical intervention. Move on in terms of what types of discrimination is covered. So under the SDA, and in fact, all of the anti-discrimination legislation covers what's called direct and indirect discrimination. So direct discrimination is perhaps the more commonly understood form of discrimination. So this is where someone is treated less favorably because of their attribute that's covered under the law than someone who does not have that attribute in similar or the same circumstances. So a practical example of that is if a shop assistant refuses to serve a person who presents as a woman but has a deep masculine voice because that shopkeeper is uncomfortable about that person's gender identity. In a disability context, if someone's offered employment but then later that offer is withdrawn because the employer finds out that they have previously made a workers' compensation claim or has a disability, that could constitute direct discrimination. In terms of indirect discrimination, and that particular image there is meant to sort of depict I suppose, what indirect discrimination could look like. So this is where everyone is treated the same. So where everyone's subject to the same requirement or condition is how it's described in the law, but that same application, so that's equal treatment, disadvantages a person or a group of people because of their particular attribute, and that's not reasonable in the circumstances. So, for example, it may be indirect gender identity discrimination under the SDA if an organization's human resources policies, for example, does not permit for employees to change their employment records. So such a policy may require a transgender woman to continually disclose information about her gender identity in order to explain discrepancies in their personal details. So Joel spoke to that issue around constantly having to explain those discrepancies to service providers, for example. So that potentially could be an example of indirect discrimination. In addition to direct and indirect discrimination on the basis of sex and gender identity, under the SDA, there's also protections against sexual harassment. And I won't cover this in too much detail, but we do know, and in terms of the complaints experience, that certain segments in society experience sexual harassment at a higher rate, including women and also people of gender diverse backgrounds, as well as Aboriginal and Torres Strait Islander women as well. So under the Sex Discrimination Act, in employment and in the provision of goods and services, it is unlawful to sexually harass an individual. So in terms of the definition, it basically involves three components. So the conduct has to be unwelcome and has to be of a sexual nature and has to be in circumstances where the reasonable person would be offended, humiliated by the particular conduct. So that particular slide that I've got on there gives you some examples of what may constitute sexual harassment. So things like unwelcome physical touching, staring or leering, emailing pornography, sending unwanted sexual messages, suggestive comments, etc. Under recent law, changes to the legislation last year on 11th of September. All workplaces now are protected from workers are protected from sexual harassment. So this actually includes volunteers as well, which is not covered under the other provisions of the anti-discrimination legislation. It also covers students and those who are self-employed and applies a broader definition of the worker, which is found in occupational health and safety law. The reason I thought I'd just mention this is we do commonly get a lot of complaints, in particular in employment, from individuals who identify as transgender, where the comments made by co-workers or managers, supervisors also may constitute sexual harassment as well. So comments of a sexual nature particular to an individual's gender identity. So we would accept a complaint on the basis of sexual harassment as well as gender identity discrimination as well. I might move to the next slide. Sorry. In terms of the types of complaints we get and the proportion of complaints, so overall, the Human Rights Commission, we received 3,736 complaints last financial year. So this represented a 20% increase in the previous year. In terms of the composition under those 4 pieces of legislation that I mentioned before, 52% of those were lodged under the Disability Discrimination Act. So consistently we get the majority of complaints under the DDA, in particular in employment, and 16% were lodged under the Sex Discrimination Act. This particular table that I've got in front of you on the slide breaks it down in terms of the various grounds. So you'll see there that the vast proportion of complaints under the SDA are in relation to sex discrimination, so 418 or 32%, and then sexual harassment, so 292 or 23%. We did receive 82 complaints alleging gender identity discrimination, which constitutes 6% of all the complaints lodged under the SDA. As I mentioned, an individual can make a claim alleging 1 or more grounds. So we can get a complaint, as I mentioned, alleging sex discrimination and race discrimination, for example, or gender identity and sexual harassment. So a person's not confined, obviously, to make a complaint under one piece of law or under one grounds. Obviously, that recognises intersectionality of people's experiences with discrimination. I thought I'd maybe highlight a couple of examples of the types of complaints that we have received alleging gender identity discrimination. So I'll go through 4 examples. What I'll do for now is just describe to you the type of cases, and then at the end, I'll talk to you about. So these are actually all complaints that the Commission has received in the last couple of years, and they've all gone through a conciliation process, which I'll speak to, and I'll talk to you about the outcomes that were achieved in that conciliation process at the end. But for now, a common type of complaint that we do get is in the context of employment. So I think Joel encapsulated that so eloquently in terms of his unfortunate experience in employment during the transition period. That's quite a common experience that we receive in the context of our employment complaints, unfortunately. So there's a lot of issues around stigma, around exclusion, and around harassment and bullying on the basis of gender identity in employment. So this particular case study refers to a transgender woman who commenced gender transition shortly after starting her employment, and she was a store person at a warehouse, and she essentially spoke about her experiences in being isolated in the workplace, so not being invited to social functions in after hours, or generally excluded from meetings, and generally avoided in the workplace after she commenced her transition, which she announced to her colleagues. And also it sort of related at the same time she injured her back, and she essentially then claimed that the employer terminated her employment because of her injury as well as her gender identity. So you can maybe see in this particular complaint, the complainant had made a complaint alleging disability discrimination with respect to her back injury, as well as gender identity in employment discrimination as well, relating to the isolation and then the termination of employment. So unfortunately, that is a common type of complaint we get in the context of employment, around that stigma and around a lack of understanding and sometimes quite hostile behaviour from staff or colleagues. The next example goes to, I've said dress codes, but it can be in relation to uniforms. And this particular example is in relation to a function or an advertised function. It was a charity event that was run by a not-for-profit. So in this instance, the complainant's sex assigned at birth was female, but they identify as non-binary, gender fluid, and same attracted to women. The complainant wished to attend an event hosted by the respondent. However, the dress code for the event specified that women must wear a dress and men must wear pants. The complainant alleged that the respondent declined their request to wear a shirt and pants. So we get these type of complaints with respect to dress and uniforms by students in schools as well. So we had a couple of cases in the last few years from students in primary and high schools where the schools did not agree to wear their uniform that accords with their gender identity, or there's specific uniform policies that prohibit against flexibility in terms of being able to wear uniforms that accord with one's gender identity, and also in relation to work dress codes as well. It's a common type of complaint that we receive. The next group relates to use of amenities. So this is where a service in particular is not providing appropriate amenities or refuses to provide amenities to gender diverse individuals or customers. So, but in this particular instance, we had a transgender woman who claimed that that she attended a respondent swimming pool. Staff made rude comments to her, referring to her male-like voice, and she said she was also refused access to the female change rooms and toilet facilities. So we did get a raft of, unfortunately, complaints around swimming pools and gyms, in particular, not providing a suitable amenity for gender diverse customers. And we'll talk a little bit later about how those particular complaints were resolved. Finally, I suppose another common group of complaints we get is in relation to change of records. And again, I referred to Joel's presentation earlier about their experience in that regard. So particularly, I remember this particular complaint given that I handled it, but she's a transgender woman who attended a branch office of quite a large national insurance company, wanting to update her personal records to reflect a change from male name to female name. So she had already officially changed her name through the relevant births, deaths and marriages in this particular instance in New South Wales. And she essentially made a complaint in relation to how she was treated by staff, but also the process in which the records change needed to occur. So she said that staff at the company asked inappropriate questions about her gender identity in front of other staff as well as customers. It was in the actual service cubicle, and included asking her whether she had had a sex change operation. The complainant also claimed that after she suggested that the respondent amend its processes to make it easier for transgender customers to be able to make a name change and sex on their record, she was advised that, look, this really isn't an issue that comes up a lot. So thanks, but no thanks. So kind of dismissing her particular concerns there. I'll move on really quickly to the actual Commission's complaint process, but what I thought I'd highlight to you, I guess alluding or going on from Joel's comments about, well, how do you find out about what your rights are? You know, what kind of support is available? You know, what kind of complaints can you make? Who can you go to? I just wanted to give a shout out to our National Information Service. So we provide information about, you know, individuals' rights and responsibilities under federal human rights and anti-discrimination law. We can give you information about how to make a complaint and how the law might apply in a particular situation. And we can also talk to you about the specific complaints process, and for respondents, how to respond to, or, you know, what you should be doing in the context of having to respond to a complaint to us. And we can also refer you to other organizations if we can't assist you. In other words, if we don't cover what your particular issue is. Just for context, last year, the Commission received 23,200 inquiries, which was up a 47% increase from the previous year. A lot of that was related to COVID-related inquiries. In terms of the actual complaint process, so really quickly, all our complaints, in order for us to be able to accept a complaint, it must be in writing. However, we do provide assistance to individuals for whatever reason if they can't put a complaint in writing. So we can take a complaints statement from you, and we can contact you through the National Information Service. You can also lodge a complaint in a language other than English, and we can get that translated, obviously, as long as we know what language we need to get that translated in. There's no fee for making a complaint to the Commission, so it is a free service. It does not have to be made by what's called the aggrieved person under the law, so it can be made on behalf of somebody. So sometimes we do get complaints made by a family member on behalf of the individual, parent on behalf of a child, and also can be made by an advocate or obviously a legal representative as well. You don't have to be represented by a lawyer or an advocate to be able to make a complaint, but you also equally can have representation through our process as well, if that's what you choose. There are some timeframes around when you can make a complaint. So I do need to flag that these are discretionary. Yeah. So essentially what the relevant law says that the Commission may decide not to investigate or conciliate a complaint of unlawful discrimination if it's lodged more than 6 months, and this is specifically for complaints made under the Disability, Race and Age Discrimination Act, and it's 24 months for any complaints made under the Sex Discrimination Act. Now, the difference there is last year on the 11th of September, there was some significant changes to the SDA that expanded that time frame for being able to make a complaint under the SDA. If you are lodging a complaint that you're outside of those particular timeframes, simply let us know the reasons. Sometimes there's very good reasons why a complaint wasn't made within those periods of time. If you let us know, that'll be taken into account in terms of our consideration of our inquiry. I'll move really quickly through this. So I won't go through all of the different stages, but essentially when we receive a complaint, we will assess it to see whether it falls under the laws that we administer. We will then look at a particular pathway for a complaint. So sometimes we might need further information from the complainant. We might seek a written response. And generally, most of our complaints will follow a pathway where we go to conciliation, where we are trying to assist the parties to resolve a complaint through a statutory conciliation process. And then if the matter is resolved, then that's maybe formalized through an agreement between the parties. Otherwise, if it doesn't resolve, we will issue what's called a termination notice that enables an individual to take the matter to the federal court. In terms of the conciliation process, so we offer a flexible and confidential process. It's in different formats, so we really take into account the needs of the parties, the complainant and the respondent, the type of matter in terms of what type of format might work. So we can offer conciliation conferences via telephone, video conference, or in person if required, or through a shuttle process where the Commission passes messages between the parties. So parties might not necessarily meet together in that sense. In terms of our role, we are impartial. So we don't represent a complainant, we don't represent a respondent, we don't provide a view about whether there is definitely unlawful discrimination or not. We can provide information about how the law might apply if the matter were to go to court, and provide resources and information to assist the parties to make informed decisions. Ultimately, how a matter resolves is up to the parties, and we can give suggestions about how matters can resolve. We can generate options, but we can't tell a respondent that a complaint needs to be resolved in a certain way. We have a conciliation register online on our website that provides examples of de-identified complaints that have resolved through our process and gives you an idea of the outcomes that have been achieved. So if we go back to the case study, the first one on employment. So if you just remember, it was in relation to being excluded from the workplace. If we just go to the next slide, this particular complaint was resolved with an agreement that the employer, so essentially the complainant came to a view that the employment relationship was essentially untenable, and that she did not want to continue working there. So an agreement was reached with the employer around ending the employment relationship. The complainant was provided $30,000 in general damages to characterize the end of the relationship, and also tendered her resignation, and they were provided with a detailed statement of service there. In relation to the next case study in relation to the dress code. So if you recall, it was about the specific event that required you to, if you're a woman, to wear a dress, and if you're a man, to wear suit and pants. This particular complaint was resolved with an agreement that the respondent would in fact allow the event participants to wear formal attire that does reflect their gender identity, and advised participants who had made inquiries about dress codes of the change of this policy. So it was able to be implemented prior to the event, which was great. The respondent also undertook to remove statements about the requirement for women to wear dresses and men to wear pants on its website, and also agreed to donate an amount equivalent to the cost of the complainant's ticket to an agreed charity that was nominated by the complainant. So there was a range of outcomes there, financial changes in policy and practice as well there. And then in relation to the change room situation with the swimming pool, this particular complaint was resolved with an agreement that the swimming pool provide the complainant with access to the female change rooms and also to an enclosed cubicle in the change rooms as well for them to be able to use. And they had changed their policy in general around training to staff about sensitivity in relation to gender identity, customers who identify with diverse gender identities. That final case study around the insurer and the change of records, this was quite a significant outcome in that, given that it was a national company, they took the complaint really seriously, had the benefit of a very passionate and very rights-focused individual complainant, and they agreed to implement national training on gender diversity and interstate status discrimination to all of their staff. There was also a range of other systemic policy and procedure reviews and changes in their processes, which mainstream gender diversity and interstate status issues into their business service processes. There was also an agreement to make a $5,000 donation to an NGO of the complainant's choice. And what was also really great was that the complainant was able to provide a presentation to the management team to inform their process and policy changes. Just finally, in terms of if a complaint can't be resolved, so in terms of just general statistics, about 50 to 60% of the complaints we do take to conciliation do resolve with an agreement being reached. However, not all complaints can be resolved through our process. If a complaint can't be resolved, then a complainant does have the opportunity to take the matter to the federal court. They must apply within 60 days of the commission terminating the complaint. And it's the court that decides whether or not there's been a breach of the law as alleged by the complaint. It is currently a cost jurisdiction, so which means that the unsuccessful party, whether that be the applicant or the respondent, may bear the legal costs of the other side if they are not successful. So look, that is a significant barrier in terms of people taking matters to the court. Fortunately or unfortunately, we actually don't have any federal case law on gender identity discrimination at the moment. So I am aware of some state and tribunal decisions, but in the federal jurisdiction, we don't have any sort of useful case law around interpretation of the gender identity provisions under the SDA. It's important to note that the Commission doesn't act for a complainant or respondent in the court matters. So I'll end there. If you do have any questions or would like any further information, our website is a trove of information around the complaints process. I understand you'll be provided with some links as well for some useful resources, and I encourage you, if you have any questions, to call our National Information Service. Thank you very much.
Thank you very much, Shamika. I'm just conscious of the time, so Hilary, we might go straight to you now, and I'll stop sharing my screen so you can share yours.
Great. So, hi everyone, I'm just going to share my screen and get my slides up. Okay. Can you please put your hand up if there's any of you who can't see my slides? No, we're all good. Okay. So I'm currently working at the Inner City Legal Centre in King's Cross. We are a community legal centre. So there are two different kinds of legal centres. There are legal centres that specialise in a particular area of law, and there are legal centres that deal with a particular geographical area, and the ICLC is unusual because we're both. So we have a statewide legal service for LGBTIQ people, a statewide legal service for sex workers, and a generalist service that serves the inner city, the eastern suburbs, the northern beaches, and the North Shore. Our specialist service is not means tested, which is important to know. So, bit of a disclaimer, the information that's provided in this presentation is not legal advice. I'm assuming minimal knowledge of the subject areas that I'm going to talk about. If I am wrong in that, then I apologise. Hopefully it won't be too boring for you. I'm covering a fair bit today, fairly quickly, and these slides will be circulated, and also links to some of the resources on our website will be circulated. So the reason why this is important, I understand that a lot of people who are attending this presentation are non-legal workers, and because there are such difficulties with access to justice for most, if not many people, non-legal workers are routinely the only points of contact with a professional for many people with legal problems. So obviously, the ability to give legal advice is restricted to lawyers, but what I hope to achieve through this presentation is to give you a little bit of information about some of the legal issues that trans people come across frequently, and a very potted overview of the way the legal system works. So one of the things that Joel spoke to so compellingly is that a lot of people think of the experience for trans people as being one of finite vulnerability, that someone will transition and then they'll be fine, and then they'll just go through life and this won't be an issue for them anymore. And that's unfortunately not the case, or at least very rarely the case. So issues with ID can, for instance, recur, and that will force people to out themselves. And also a lot of trans people, because of the discrimination that they suffer, can often simply be more vulnerable in dealing with large institutions, and are more likely to end up with criminal charges against them, or with, for example, onerous bail conditions if they do end up on criminal charges. So I'm going to talk about systemic disadvantage very briefly, how we get information, the court system, getting legal help, identification, fines, apprehended violence orders, and crime. So unlike Shamika's presentation, which was a very thorough explanation of discrimination law and how the Commission works, I'm going to jump around a little bit. So this slide was kindly supplied by Sam Elkin at St Kilda Legal Service. So it's important to understand that for a lot of trans people, some of their experience of the system can lead to incremental trauma. So a response to an issue that may seem relatively minor to you needs to be understood in the context of that person's experience of the legal system and dealing with authority overall. So, for example, when I worked at the centre before, I did a youth outreach at 2010. And one of the young people there had not been able to change their sex on their birth certificate because of the way New South Wales law works, which I'll explain. And they had been offered a job and an apprenticeship, and they were asked to supply some ID as a part of the due diligence process, as a part of recruitment. Supplying their birth certificate outed them as trans, and the offer of employment was immediately withdrawn. I was very eager to act for that person in a discrimination complaint, but they simply wanted to move on with their life. So particularly with trans people, where there can often, not always, but often be a difference between the legal name and the name that the client goes by, it's important to understand how you can get information about what's happening. So we get information from the client, from the client's documents, and from publicly available sources. And apologies if this is telling you how to suck eggs somewhat. Your client's ability to express what they want in relation to a legal situation may vary. So there are some simple questions that really apply to almost all clients. What do you have? What do you want that you don't have now? What are your resources? And what resources are you willing to use to get what you want? So in terms of the client's documents, if it's an AVO issue, then the text of the AVO, which will show the specific conditions that apply. For criminal charges, you'll need to look at the court attendance notice, and there are two different kinds. There is a field court attendance notice, which is given by police on the spot for a matter where the person is not arrested and they're not put on bail. And the field court attendance notice is a little yellow thing that looks a bit like an old-fashioned receipt, and it will simply have the defendant's name, the court date and place and time, and the charge or charges which they are facing. Fines, employment contract and insurance contract. In terms of court orders, for a criminal court matter, you'll have a notice of court result. In parenting matters, you might have interim or final orders for parenting matters. So here are some places where you can get information from publicly available sources about issues that are to do with your client. So the ABN register will tell you the person, company, or other entity that's behind an ABN. So that'll help you establish who they're actually employed by, for instance, if it's an employment matter, or for example, who they're being sued by. If you need to find out about a company, then you can search details about a company for free on the ASIC website at asic.gov.au. That will tell you whether the company is currently registered, and it'll also tell you whether it's under external administration, which means whether it is potentially going into insolvency. And you'll be able to see the last two documents which were filed in relation to the company, which can give you a bit of an indication of what's going on. You can also do a paid search, which costs $9 to establish more information. Court list New South Wales. That will show you all matters which are listed in New South Wales courts for the last 2 weeks and the upcoming 3 weeks. So that'll help you to find out what's actually going on when a client mentions that they need to go to court. And I cannot believe it is raining so hard on my corrugated iron roof right now. The Fair Work Commission will tell you about applicable employment awards. And if you need to find out whether an individual is bankrupt, you can search that at the Australian Financial Security Authority. Okay, so the court system. In New South Wales, the lowest level is the local court, and then we have the New South Wales Civil and Administrative Tribunal. So it is a super tribunal that amalgamated a number of other tribunals which used to deal with individual issues. So if it's a guardianship matter, it'll now go to NCAT. If it is a consumer matter, home building, commercial, and anti-discrimination, if the original complaint has been made under the New South Wales legislation, it will go to NCAT. There's the local court, which is the lowest level of court. It deals with something like 90% of the criminal prosecutions in New South Wales, and it deals with money claims up to $100,000. Then there's the district court, which deals with more serious criminal matters and money claims from $100,000 to $1.25 million. The Supreme Court is the highest court in the state, and it deals with very serious criminal matters and money claims above $1.25 million. And then above that, you can go to the Court of Appeal, and then above that, you can go to the High Court. And in the federal system, you have the Fair Work Commission and the Human Rights Commission, from which you can appeal to the federal court or commence proceedings in the federal court. And from there, you can go to the full federal court. And then for some federal matters like bankruptcy and company law, you can go to the Federal Circuit Court and Family Court of Australia. And from there, you go to the full court. I've mashed together this diagram a little bit. Okay, in terms of getting legal help, Lawyers in New South Wales are divided into two separate yet equally important types. There are barristers, who are independent lawyers that specialise in court work and advice, and they are generally instructed by solicitors on behalf of a client. And then there are solicitors, who are people like me. They are lawyers that act directly for clients. In terms of legal assistance, a private solicitor will generally expect to be paid. They may be willing to do pro bono. Legal aid acts in certain matters. They have a minimum $75 contribution fee, which can be waived in some circumstances, and strict means and merit criteria. Community legal centres, just to plug community legal centres, are free of charge, and means tests may also apply. There's the Law Society Pro Bono Scheme, which your client will only be eligible for if they have a legal aid refusal. And there's the New South Wales Bar Association Pro Bono Scheme, for which you'll need a legal aid refusal and you'll need an instructing solicitor. There's also the duty solicitor or duty barrister schemes. These are lawyers who will appear on the day or who are available at court on the day. They are a free service. They're not available at all courts, and they're generally only able to give minor assistance. I think it might be hailing. Identification. So changing your name if you're a trans person, the way that you can change your name depends on your state or territory of birth. So if you were born in a state or territory of New South Wales, you must follow the procedures of that state or territory. Otherwise, if you were born overseas, you can register your change of name if you can prove that you've lived in New South Wales for 3 consecutive years prior to the application. The fee in New South Wales is $195 for standard processing or $250 for priority. Changing the record of your sex. So if you were born overseas, you can register your change of sex if you can prove you've lived in New South Wales for at least 1 year prior to making the application. Otherwise, again, the way you can change your sex on your birth certificate depends on your state or territory of birth. In New South Wales, we still have the utterly medieval requirement that if you want to change your sex on your birth certificate, you must have undergone a sex affirmation procedure as defined, and that is surgery affecting the reproductive organs. That must be confirmed by 2 doctors. I have heard anecdotally that there are doctors who are, shall I say, without being defamatory, willing to be flexible, but this is really a terribly discriminatory and medieval law that I hope will soon be changed. So Australian passports. A trans person can get an Australian passport in their affirmed gender if they can supply a stat dec from a doctor or clinical psychologist that they have undergone or are undergoing, quote, appropriate clinical treatment. It doesn't need to be defined in any more detail than that. Driver's license. So there isn't actually a sex marker printed on New South Wales driver's licenses or photo cards. However, the record that is retained by RMS can be corrected on the supply of a passport with the corrected sex or a letter from a doctor in similar terms to the passport application. Okay, AVOs. Under the relevant New South Wales legislation, domestic violence is defined as violence which happens in a domestic relationship. And so this is one of those irritating legal terms that seems like it should have a common sense definition, but it actually has a highly technical definition. So domestic relationships include people who are or have been married to each other, in a de facto partnership with each other, or have had an intimate personal relationship. It doesn't have to be sexual, have lived in the same household, have lived in the same residential facility, have been a dependent in a carer relationship, and 2 people who have each had a domestic relationship of a kind set out in subsection 1A, B, or C with the same person are also in a domestic relationship with each other. So what that means is that my boyfriend is in a domestic relationship with my ex-husband, despite the fact that they've never met. So apprehended violence orders, they fall into 2 types. There are apprehended domestic violence orders, which are made between people in a domestic relationship. They're generally initiated by police, and they can be accompanied by related charges. And then apprehended personal violence orders are made between everyone else, people who are not in a domestic relationship with each other. They are generally privately initiated because if the police dealt with APVOs, probably the system would shut down, and they're usually not accompanied by charges. So there are a lot of misconceptions about what AVOs are, so I want to be really clear. An AVO is a court order made for the protection of the person in need of protection from the defendant. It is not a criminal charge, and it will not give someone a criminal record. It will appear on the police database, which has the hilarious acronym of COPS, so that it can be enforced, but it will not give someone a criminal record. It can have different conditions, but it will always have the mandatory minimum conditions. So the minimum conditions are that someone cannot assault, harass, molest, intimidate, destroy or damage someone's property. All of those things are already illegal under New South Wales criminal law. An AVO can have additional conditions, for example, that someone not be able to contact the person in need of protection other than through a lawyer. It can have a condition that they not approach or be in their company within 12 hours of drinking or taking illegal drugs. And it can have a condition, for example, that they can't go within a specified distance of a specified place, like the person in need of protection's home or work. An AVO is not a way to prosecute someone if the police won't. There seems to be a bit of a misconception about that. So fines, I'm going to tear through this quite quickly. Fines are issued in New South Wales by way of penalty notice, and they're issued for strict liability offences such as speeding, parking offences, and some summary offences such as offensive behaviour. There's no need to prove intent for a strict liability offence, only the factual elements of the offence. So it just matters whether it happened. The only way to defend a strict liability offence is on the basis either that it didn't happen or of honest and reasonable mistake. So I'm going to skip through this because I'm worried about time. These slides will be circulated. Okay, so gender affirmation and young people. I understand some people have some requests about that. So when I talk about young people, I'm defining them the way the Family Law Act does as people under the age of 18. So there are 3 stages of medical treatment for trans young people. The first stage is puberty blockers. Those blockers delay the onset or progression of puberty. Then there is stage 2, which is estrogen or testosterone. We all know what they do. And then there is stage 3, which is surgical interventions, and that is generally limited to top surgery for people under the age of 18. It's important to understand that not every kid is going to go through all of these stages, and they may not necessarily go through these stages in order. So, for example, I acted for a young person who wanted top surgery, and they wanted top surgery before they started on testosterone for the very practical reason I didn't want to have a hairy chest and big boobs. So a court application is no longer mandatory if there is no disagreement as to diagnosis or treatment. However, if there is disagreement about diagnosis or treatment, an application to court is mandatory before the treatment can lawfully commence. And the steps about bringing a procedure like that to court are set out in the Family Law Practice Direction Medical Procedure Proceedings. A lot of medical practitioners are interpreting the decision in Re-Imagen as requiring them to have consent from both parents, even if they would otherwise have accepted consent from one parent for example, other surgeries such as having a mole removed or wisdom teeth out or something like that. Where this is difficult for a lot of trans kids is that the other parent may not necessarily be in that person's life, and they may use their consent, their withholding of consent as frankly, a form of family violence against the young person. So minor criminal charges. I dealt with in the local court. Police issue a court attendance notice. This tells them this tells the defendant a time and place to come to court, the details of the charges, and the police facts, the narrative of what they say happened. Common offences, common assault, drug offences, assault, drink driving. The first time that a charge is in court is called a mention. At this mention, the defendant has the option to ask for an adjournment for legal advice, plead guilty or plead not guilty. A plea of guilty is a plea to both the charge and the facts. It is accepting the police story as correct. So one of the issues that trans people can have in dealing with the criminal justice system is that criminal charges will be issued in the name which is attached to this CNI, which is the criminal name index, which will be, I don't know why it's called index, which is the name that the person had when they first came into contact with police, which could be their dead name. So if you are supporting a client in court and you're either not a lawyer or they don't have a lawyer, you can advocate for that person by speaking to the prosecutor and court staff to let them know what your client's current name is. So, for example, the form of words that I might use would be something like the name that will appear on the court record is John Smith. My client uses the name Jenny Smith. It's unlikely that you'll be able to persuade the court to not mention the CNI name at all. So you can support your client by letting them know about this, just so they're forewarned. So bail. When someone is arrested and charged, they can be released unconditionally, they can be released conditionally, or they can be not released, so held on remand. If someone is conditionally released, then they are on bail. It's a basic condition of bail that the defendant must attend court. The other bail conditions can include complying with an AVO, not going to a particular place, not contacting a particular person, or reporting to police. Please do not take a consistent approach in bail. That is a dramatic understatement. And trans people may be more likely to end up with bail conditions that are onerous for them. So where this can be a problem is a breach of bail can be a separate criminal offence, or it can simply just lead to a whole bunch of hassle. Bail can be varied on the application of the defendant. In some cases, if police consent, this can be done in chambers, so at the court offices. Otherwise, there'll be a court date. Bail is a complex and technical area of the law, and a bail variation is best done by a lawyer. Okay. I've jumped around a fair bit with that, but that is the end of my presentation, so I'll stop sharing. You're on mute, Bridget.
Sorry, I thought I'd unmuted. Apologies, everybody. Thank you so much, Hilary, for your presentation, and also Shamika, and also Joel for sharing your experiences. I'm just going to share my screen again because there's just a couple of slides. I don't want to run through them and take up people's question time, but just to let people know that what we didn't cover already in this presentation is the discrimination law in New South Wales. So just to let you know that transgender discrimination is against the law in New South Wales. I won't run through this in detail now, but just to let you know that you can make a complaint to Anti-Discrimination New South Wales if you experience transgender discrimination, and there is a 12-month limit. Time limit in which you need to make that complaint. We will send a copy of these presentations to all of you, including some links to more specific information. And just to let you know, these are contacts for support, and you will receive this by email following the webinar. So as Hilary said, she works with the Inner City Legal Centre, and that's their contact details. Law Access is the pathway to seek help from legal aid. Just to let you know, we do have a system of triage, and we have priority client groups for accessing legal aid. There's also other support services available, the Gender Centre, Q Life, and then there's information about the Australian Human Rights Commission. And if you experience distress or sexual violence or need to get help, we've just included this information as well. So I noticed, Shamika, that you had responded to some questions through the Q&A. Could I just check with you, did those responses go to everybody or just to the individual who asked the question?
I chose the type answer option, so I think it would have gone to everybody, but I can see it answered in the answered tab. Just let me know if you can't see it, and then I can happy to.
Okay. Thank you. Fantastic. So just wanted to go to our audience now and see if anybody had any further questions other than the ones that have already been responded to. So we have a question from Michael. How are the school uniform gender discrimination claims resolving?
I'm assuming that one's for me. So thanks, Michael, for that question. So as I mentioned, we had don't quote me on the exact time frame, but in the last 2 years, I think we had about 3 or 4. Essentially, pleased to advise that all of those complaints did resolve with the school in question agreeing to apply a flexible uniform policy consistent with the individual student's gender identity. There was also some issues around in one particular complaint about the sports uniform as distinct from the general uniform and some flexibility around that. I think there was some that issue wasn't fully resolved. However, the complainant still advised that her entire complaint in a general sense was resolved. So we are finding that the schools are responding positively, at least to the ones that have come before us. I should have mentioned that these are both public schools as well as private schools and some Catholic schools as well, so some religious education institutions as well. So it is across the different types of educational institutions.
Thank you, Shamika. We've just had another couple coming through. What about discrimination and pronoun choices?
Yep, so that's a good question. So we absolutely get complaints where more often in the context of a service provision, also in education where an individual is consistently misgendered or have not been addressed by the pronoun of their choice. So that could form a complaint alleging gender identity discrimination in that their gender identity is not reflected in the way that the service is provided, and in particular in the communication. So we get that quite a lot with call centres or sort of automated letters from government departments, for example, where someone's misgendered or the wrong pronouns being used despite updates on their system officially on the records. And it tends to be less, we'd get not so much complaints about sort of one-off instances, but a consistent ignoring of an individual's pronoun of choice, despite them advising that the service provider or the education provider of their preferences in that regard. We did have a complaint in a school about a particular student whose records were updated on the system, but a particular teacher consistently misgendered her in their address of her during the classroom.
Thank you, Shamika. Another question. Many of New South Wales service databases have limited gender pronoun options. Are there efforts to have these barriers addressed on the basis of sex discrimination?
I'm not sure who that question was addressed to, and Hilary and Joel, if you have any insight on this, please jump in. I'll be frank, I'm not aware of that. We haven't, and to be frank, we haven't received too many complaints specifically around, and I'm assuming we're talking about sort of New South Wales state government databases, perhaps. As sort of Joel mentioned, that there has been, in the cases where we have received complaints about limitations of specific databases and records keeping of agencies, it does tend to be, the resolution does tend to be about sort of a long-term focus. So an agreement to re-engineer the system within a period of time to make sure that their records databases accurately records and captures individuals' gender identity. So I can, I guess, comment from an individual complaints perspective that there has been, I can't comment on specifically on New South Wales though, but there certainly have been complaints which have resolved by individual service providers, state government departments, as well as private organisations undertaking a long-term project in terms of updating the databases to accurately capture individuals' personal records, including gender identity markers.
I think one of the other issues with that is that databases, as Joel pointed out as an engineer, are fundamentally a bit of a clumsy tool. So, for example, my practice management software, it allows me to have multiple different honorifics that reflect different gender identities, but it only allows me to select male or female as a gender identity. So I am definitely not trying to minimize it as a problem, but I think sometimes it's just a question of the technology.
Yeah, and it definitely is a long-term thing to unpick those things that have largely just been embedded because the software engineer has made the assumption that if you have female in a box, then you're only ever going to want to choose Miss, Mrs, or Miss, you know, like that. It's embedded in assumptions that just get built into software, and it is widespread in public and private sector. So.
And just on that point, I'll let our audience know that Legal Aid is aware of the limitations of our data collection, and there is a project to work on overhauling that and improving that to recognise the diversity of gender that we have in the community. We have another question, which, Joel, I think is for you. How can families, well, I guess anybody may wish to comment, but I think it's probably most directed to you, Joel. How can families best emotionally support trans kids navigating coming out?
Yeah, I think yes, this is a very big question. In supporting a family member, I think first and foremost, going any of that kind of questioning or discomfort, you know, anything that you might need to go and unpack that separately and let that person know that you're there for them and that you love them and that you support them. So an example of, I was actually very fortunate. My dad, you know, when I came out to him, or I was trying to, he said, I can see whatever you're trying to tell me is obviously harder for you than it is for me to hear. And then once I came out, he said, well, all that you need to know is that I love you and the rest is for me to work out. And I think when families can just get around that person and just let them know that even if it is hard, even if there are things for them to go and understand and learn and unpack for themselves, the main thing is that you're there for them and that you're going along that journey with them.
I'd also like to give a plug for 2010. They have fantastic groups for young people ages 13 to 26. Some of them are in person in Sydney, but a lot of them are online on Discord. And I'd also like to plug Transtopia, which is a service of the Gender Centre. And something that I've observed through working with a lot of families is just to follow on from what Joel said, that there isn't one way to be trans, and there certainly isn't a right way to be trans. So in supporting your kids in coming out, let them have the narrative that they need to, and also understand that it's a series of small decisions rather than an enormous binary decision.
Sometimes it's a journey that goes all over the place. It's come out 3 times. My parents have been along the trip. And I'd encourage for parents particularly to reach out to other parents, connect into community yourself, and foster that community, around you and your family, and make sure that you've got people that you can kind of share and learn and have that solidarity with.
So the Gender Centre has a parents group, which has really helped people with that process.
Yep.
Hilary, do you know if they offer online for people that might live in regional areas outside of Sydney?
I don't honestly know. I know from dealing with them in the past that they have had kind of satellite groups, so in regional centres. But I would just really encourage people to get in touch with them, because although it's a journey that I think parents should be sorting out themselves, they do need to have support in going through that process, because it can be a really isolating experience.
Thank you. It doesn't appear that we have any further questions, and we've reached the end of time for our webinar. So I would like to say a very big thank you to all our presenters today for sharing your time and expertise, and thank you to our audience for joining us. And if there are any further questions, feel free to send them through to sealy-webinars@legalaid.newsouthwales.gov.au, and we will forward them on if we're unable to provide the answer yourself, and ensure that someone answers them. And you will receive an email a day after today's webinar with a lot of information and links to services that we've referred to during the webinar. And we'll also send a copy of the presentation. So thanks for joining us, everybody. And thanks again to our panelists. Good afternoon.